Hi, my name is Paymon Aramjoo, and I appreciate you tuning into this presentation on what we've called the Chiropractor's PI Handbook. We've put this presentation together because we think it's important to try to reestablish good relationships between chiropractors and attorneys. And it's important because it can ultimately result in chiropractors getting paid, protecting their time in all the time they treat the patients for, and partnering well so that the process goes as it should. And I want to first welcome you by telling you who I am. I'm a personal injury attorney and I'm a co-founder of Aramjoo Law Firm in Liberty, Missouri. And myself, as well as my wife, founded the firm in 2014, ultimately now specialized, or I should say, only practicing personal injury cases, predominantly motor vehicle accidents. Today's focus is going to be on trying to build strong partnerships between attorneys and chiropractors. And I'm hoping that at the end of this, you'll gain an understanding of liens, both contractual and statutorily. I want to make sure that you understand some strategies to make sure that the care you provide is paid for. And I also want to make sure that there's stronger collaboration between attorneys and chiropractors to ensure that our clients have good outcomes. At the end of this, if you're interested, I can also send over some example documents such as the hospital lien notice and some contractual lien documents. The problem. The problem is this, the chiropractors and attorneys are both here to help, but we're not working together to help each other. A lot of chiropractors are really uncomfortable working with attorneys on liens, often because they've had really bad experiences in the past and not having their care paid for. And here's the interesting thing is that if you were to ask most chiropractors as to why they got into doing chiropractic care, the answer they would oftentimes give is that they were here to help. They want to make sure that people get better from the issues they're experiencing. But the interesting thing about this is also attorneys oftentimes state that they're here to help. They want to make sure that their clients recover for the harms and losses that they suffered. And the best way to ensure that both chiropractors and attorneys are able to help people most successfully is to collaborate, to make sure that law firms are able to work with medical providers and medical providers are able to work with law firms that are both sincerely interested in helping the patient and their client get better and recover for all the harms and losses that they suffered. Here's the truth, too. Lien work cannot be done without attorneys. Uh, you can work most successfully on liens when you have a good relationship with an attorney that'll ensure that you're paid for the work that you are doing. And also, personal injury attorneys cannot do the work without the medical providers to get patients better. And so it's important that they work together because neither really can do the work well without each other. And there's unfortunately been a terrible dynamic in the past between healthcare professionals and attorneys. And I'd like to restore that relationship to make it more as a symbiotic relationship, much like Nemo in the Anemone, and that they both need each other and they both help each other tremendously. So, what us got us into personal injury law? Our ultimate path to personal injury isn't necessarily positive. It was really tragic. In 2020, I had lost my father to a fatal motorcycle wreck. And we got to experience firsthand a process that really dehumanizes the loss that you suffer in an accident of this nature. And after experiencing the loss, we decided to wholly invest our practice into personal injury and try to help people through the harms and losses in the process so that they can tell their story and get better along the path. And it was a huge shift for us. We decided to build a law firm just dedicated to helping injured clients. And our mission for those clients is to educate them, empower them, and advocate for them. And what's really fascinating is that our roles with chiropractors are complementary. They help heal the body, and we pursue justice for our client. But when we work together, we can have clients that heal faster, and we can ensure that their cases are resolved much more smoothly. So, why is it that lien-based care matters? Traditional healthcare doesn't always address the patient's needs. Oftentimes, patients will go to emergency rooms, then they might go to their primary care doctor, and then they're going to go through sometimes weeks of physical therapy only to be able to then finally have the insurance approve an MRI. And sometimes that MRI will give you results that indicate that the physical therapy never would have resolved the issue in the first place. And the history of lien care is really interesting. It came from the Great Depression and a time where people couldn't afford to get the medical care just simply because they didn't have the financial resources to pay for it. So it became important that providers were financially protected, but also patients could get the care they needed without some of the walls in their place, such as the financial inability to pay. And it sort of bridged the gap between injury and justice for clients. And so attorneys and chiropractors, we get to serve the same person. We just do it in such a different way. So let's first talk about what a lien is. This word gets thrown around so often, and we don't often define it. And it's a legal right for payment from a settlement or a verdict in a case. And it's the payment protection to the provider. When we say liens, there's really two main types. There's statutory liens and there's contractual liens. When we talk about statutory liens, there are actually laws in the state of Missouri that protect healthcare providers. And that term in of itself actually is a term that needed to be defined. And in a case involving Marvin Chiropractic, the case was interpreting whether or not chiropractors fell within the hospital lien statute, in which they ultimately said, yes, they do. You can also have contractual liens. But it's important to know that the statute in Missouri, it preempts contractual liens. In other words, it sort of overrides what may be in a contractual lien. But for a contractual lien, you'll want to make sure that you get a written agreement signed by the patient. You'll want to make sure it includes the patient's name, the provider's name, a treatment acknowledgement, and language about the payment from the settlement. And it's also important to provide a copy to the attorney and the insurer if you know it. So if you have a lien, in other words, if you're treating as a result of somebody's injury, or if you have a contractual lien, nonetheless, it needs to be perfected. And in order to perfect a lien, there's specific requirements that have to be followed. And this is really in particularly regarding to hospital lien statutes and making sure that you're paid as a result of the work that you do when somebody's injured. First off, it has to be sent by certified mail. And when it's sent by certified mail, you have to include the name and address of the injured person. You have to include the date of the accident, the name and location of the healthcare provider, and the name of the person, firm, or corporation who is allegedly liable for the injuries. But it's important not only that you send it certified, but you also need to send it certified to specific people. And what the law in Missouri says is you definitely have to send it to the person who is alleged to be liable. You also should send it, if you know, to the insurance company. But it's also wise to send it to the law firm handling the case for the injured party, because in many cases, they'll ensure that you get paid from the settlement or verdict. But what's important also is timing. It's important that you send notice before the money is paid to the injured person. If the notice is sent after the money is paid, then your lien doesn't become effective. It's not perfected. One way to gauge this is simply to ask your patient, has there been a settlement? And if there has been a settlement, it may not be a case that you can treat on a lien because you may not be able to get the notice out before the money is actually paid. How this should work is that after you provide the care to the patient, you get paid. It should be that simple. But there are times in which cases are complicated in that there may not have been enough insurance coverage. There may not have been the facts that really helped the case. There may have been a delay in treatment that jeopardized the attorney's ability to prove that the injuries were caused by the accident. And so there may be times that the outcome just isn't what everybody hoped it to be, and the money just isn't there to pay for all the work provided. And if it goes as it should, money is sent directly from counsel who represents your patient to satisfy the amounts owed. Sometimes that doesn't happen. And when that doesn't happen, it becomes important for you to be able to enforce a lien. And in order to enforce a lien, you have to know who's responsible for payment. And who's responsible is actually rather powerful. If a lien is sent with the proper notice and it's perfected, then any person, firm, corporation, including the insurance carrier, may be liable for the sums of money not paid. But it's not always the best path to sue. That can involve lawsuits. It can involve, of course, attorney fees. And so it may be better to start with a demand letter. And you may be surprised how often attorneys and insurance companies may come to the table to try to resolve a dispute so that they don't have to hire counsel to litigate the matter. It's also important to communicate with the attorney who's handling the matter. They may be able to rectify the situation. You may ultimately have to consider legal action, but as a practical matter, the best solution to this is to be proactive and to only work with attorneys or law firms who you have a good relationship with so that you're made aware of what's happening and potential outcomes as well. Now, the lien statute, if everything's been done to actually effectuate it, there are some caps, and the caps control how much money can be taken from the client's settlement. And in Missouri, the most that can be taken is 50% of the net settlement to the client. And knowing how the math is done can really help you navigate confidently how much money you're entitled to. Let me do some simple math. And the way it would work on this is to get to the client's net settlement, what you'll need to know is the attorney's fees, the costs and expenses, and any other liens in the matter. And $100,000 just becomes a simple round number that we can work with. Most attorneys, as far as pre-suit, will charge somewhere in the neighborhood of a third. So if we use $35,000, that's going to remain $65,000 that could be paid to the client. But of course, there's costs and expenses. There may have been investigation, there may have been accident reconstructionist, there may be professionals that are going to result in payment taken from the client to satisfy the service offered. After those fees, we could, of course, make up a number, 15,000. You'd come to a net payment to the client of $50,000. That $50,000 is, of course, the maximum amount that the liens can use of the settlement to satisfy the liens. And so if you take two lien providers, each with an equal $25,000, you'd see that the result is that you'd have 50% of the net settlement that each lien holder could take. In order to calculate the hospital lien statute, if somebody were to call you and say, look, the lien statute is going to result in a minimization of the amount paid, you will want to know what the attorney fees are, the costs and expenses, and of course, any liens in the matter to be able to actually determine what amounts are payable or you're entitled to. What I want to say again is that there should be a collaboration because the partnership between chiropractors and personal injury attorneys is critical. There is a shared mission of helping people, both aligned in helping recover and heal. Also, providers may depend on attorneys to protect their bills, and attorneys rely on chiropractic or medical care in our demand letters to support the value and treatment and also to help our clients recover. If we can communicate and collaborate along the process, then our clients win as the outcome. Some important takeaways. It's always important to get a signed lien agreement. Even if there's a statute that preempts the contractual lien, it sets expectations for the client, the provider, and the attorney so that everybody knows what they may be entitled to. Also, it's important to communicate with the attorneys early and often. If you communicate with the attorney, you'll know what the status of the case is, and you'll know what likely outcomes may be obtained. You can also ask about case viability and insurance. Is this a good case? Is this a case you think you'll be able to collect on? What sort of facts were involved in the accident? All these questions will help give you answers to understand how it is that this case may be to treat on a lien. But also, choose attorneys to work with who respect and protect your time and care. All too often, the biggest issue may be that you don't have a good relationship with an attorney, and they may not be respecting the care that you provided by keeping you informed and helping you understand the status of the case. Leaving you in the dark doesn't put you in a position in which you're going to want to treat clients on a lien. So if I treated a client on a lien, what I would do, and I've been doing this on of course, the attorney side, and I've taken chiropractors out to lunch and breakfast and coffee and understanding their pain points. I would first want to know the facts of the case because you will not get paid unless there's a recovery on the case. And the way that you can know the facts of the case is you can ask for a copy of the police report. You can talk to the attorney about the case. You can, of course, talk to your patient about the case and try to gauge as much information as you can to decide whether or not this is a proper case to treat on a lien. Also, if the attorney is willing to, or if the insurance company has already disclosed, you can ask what the limits are and whether or not they can be disclosed. Knowing how much insurance coverage is on a case can be critically important to know whether or not you may recover or not. Additionally, work with attorneys you know, like, and trust. When you work with an attorney that you know, like, and trust, they're going to keep you informed along the way, and hopefully they'll make sure that you know what the outcome is and why the outcome is what it is. And keep in routine contact. We sincerely appreciate it when providers call us and ask us what the status of the case is, because it gives us an opportunity to learn about the status of the treatment, but also an opportunity to update the provider as to where things are. So, in summation, what I'd say is there needs to be a better relationship developed between attorneys and chiropractors. There can be a successful way to treat people and to get compensated for the work that you do. And you do amazing work. Some of our clients, after being involved in accidents, are not doing well. And after they see their medical providers, it can really help restore a normalcy to their life. I thank you for your time, and I look forward to continuing the conversation.